The Town of Los Gatos Planning Commission meeting of Wednesday, May 8th, 2019 is now called to order. Please take a moment to silence your devices. Ms. Zarnowitz, would you please call the roll?
Yes, thank you. Commissioner Badami?
Here.
Commissioner Birch?
Here.
Commissioner O'Donnell?
Here.
Commissioner Tavana?
Here.
Commissioner Janoff?
Here.
Vice Chair Hansen?
Here.
And Chair Hudas.
Here. I would ask everyone stand and join Commissioner Janoff in the Pledge of Allegiance. As the Planning Commission conducts this meeting this evening on behalf of the Town Council and the residents of Los Gatos, we encourage active participation, which is essential for democracy and critical to work of the Planning Commission. That participation can occur through written comments about agenda items submitted in advance, which we always find helpful. And also during the meeting, there are two opportunities for members of the public to participate. During our meeting, there is the verbal communications period where an individual may speak on any item that is not on the agenda. And then, of course, during specific hearing items, the public may speak about that item that is on the agenda. If you wish to address tonight on any of these, please fill out a speaker card and turn that in to the closest staff member. When you speak, I ask that you come up to the podium and adjust the microphone so that you're speaking directly into it, and please limit your time to 3 minutes in fairness to all that would like to speak at the meeting. So the first item is verbal communications, and members of the public may speak on any item that is not on the agenda. Do we have any items, any speakers on that? I see all these are on item 4, so we'll move on to the next item, which is the consent calendar. We have 3 consent items to be acted upon in a single motion, and before the Planning Commission acts on the consent calendar, any member of the commission or the public may request that the item be removed from the consent agenda. Those items would be placed either at the end of the meeting, or as the first item that follows. Tonight we have 3 items. Let's see. We have the minutes. We have we have the town code, I'm sorry, that's the third item. And we have 460 Monterey Avenue, and we also have the town code amendment on hillside fences, and that item, I believe, has been scheduled for May 22nd, and a draft of that ordinance has been provided to the public. So do we have a motion on the consent calendar? Commissioner O'Donnell?
I move that we approve the consent items as enumerated 1, 2, and 3, and in particular the dates suggested for 2 and 3.
Thank you. Commissioner Birch?
I'll second the motion.
Okay. All in favor? Opposed? Passes unanimously. So now we move on to item number 4, which is 11 and 15 Peralta Avenue, subdivision application M-19-001 and variance application V-19-001, requesting approval of a variance for a lot line adjustment between 2 lots for property zoned R18, APNs 510-42073 and 074. Property owner Wendy Kandasamy Trust, and applicant Tony Jeans. Project planner Aaron Walters. May I have a show of hands from commissioners who visited the property? Are there any disclosures? Okay. Thank you. Ms. Walters, would you like to give us a staff report, please?
Yes, good evening, Commissioners. The two subject lots, 15 and 11 Peralta, are located on the west side of Peralta Avenue. The R18 zone non-conforming lots are each development with single-family residential uses. The project proposes a lot line adjustment between the two legal lots in order to remedy an existing condition in which the residence at 15 Peralta crosses the property line onto 11 Peralta. The existing detached six-car garage also crosses the property line between the two properties. The project's being referred to the Commission because the lot line adjustment would require a variance to reduce the required lot size, lot frontage, and north side setback for 11 Peralta. The applicant has provided a letter of justification and supporting analysis of how the proposed reduced lot size, lot frontages, and setbacks are compatible with the existing neighborhood, and these can be found in Exhibit 4 and 7. Staff recommends approval of the lot line adjustment and variance applications as the lot size, lot frontage, and setbacks would be compatible with the immediate neighborhood than they are currently, and also remedy an existing condition. And there's a desk item tonight in front of you which contains additional public comment and legal analysis from the town's attorney, and staff's available for questions.
Any questions of staff at this point? Okay. I have a number, but I think it would be better to hear from the public first, so I'll hold off on those. We now invite the applicant to come forward and provide us with their overview, and you have 10 minutes, please. So, Mr. Jeans, you're speaking for the applicant? Is that correct?
Yes.
Okay, thank you.
Okay, thank you. So Tony Jeans, P.O. Box 1518, Los Gatos, California. There was some confusion that went out about this property, and many of the letters that I've seen from neighbors and concerns that I've heard reflect the fact that the houses are going to be so close together. So I wanted to talk about that first. This is what we're actually trying to do. This is the exhibit, the legal description that basically says you have two lots. Here is lot number 1, and here is lot number 2. This is 11 Peralta, this is 15 Peralta. What we intend to do is move this lot line a few feet across and change the square footage of this lot from 8,000, which is conforming, to 7,000 square feet, which is non-conforming. This one will go from 4,000 square feet to 5,000 square feet. This is a non-conforming lot at present for different reasons. It has 50 feet of frontage when it's meant to have 60. This one has 25, which is way non-conforming. And then there are a couple of other setback conditions that make it non-conforming based on the structures on the lot. I think the best way to explain this is why we're doing it. Let's put it around the same way. The building on 11 is entirely on the property. Here is the current lot line. There is a garage at the back. There are some stairs coming out the side, which are about 20 inches from the property line, from the Fox's property line, which is where I think some confusion came from in people's interpretation. But let's have a look at what we're really trying to achieve. When you look at lot 15, there is the lot line. It runs right through the other primary residence on the property. What that means is that the owners can't even go in and get a kitchen remodel. They can't do anything because it's non-conforming. It's got the property line running through the house, and it throws up all sorts of red flags when you try and do anything. So they have no right to do anything to it. It's a lot of deferred maintenance. It's unworkable. So what we want to do, as I said before, is move the property line so that it runs neatly between the two properties and allows those to be treated properly as primary residences. One on legal lot 11 Peralta and one on legal lot 15 Peralta. In doing that, let me backtrack. An attempt was made to do this in 2001 when the certificate of compliance was awarded to this property where the town says, yes, you do have two lots. When they asked for the lot line adjustment in the same hearing, they said, you don't have sufficient information, your map is wrong, and you haven't said what you're going to do with the garage at the back, which would straddle the property line. So that was dropped at that time and was never reapplied for. What we're doing is reapplying for it. There is a condition in the planning and engineering approvals that say we have to arrange to demolish one of the bays of the 6-car garage and make it into a 2-car garage and a 3-car garage so that the lot line will go through an empty space and not a garage. That is a requirement. That also, if you move back a little bit to the project that you approved earlier, it enables us to subsequently come along and make this larger and this larger down the road so that they're larger garages that will be more usable and therefore help the parking situation on the street, which neighbors have said are concerns of theirs. This hearing, though, is simply to rectify a problem which is untenable, to move a property line from point A to point B and make it workable so that they can live with a primary residence that you can do something to. That's all this is about. It's not about moving a house. It's not about making the houses close together. It's not about doing anything like that. And in fact, if you do look at one of the tables that was handed out as one of the 12 million sections that you have, there is residence on 11 and 15. The yellow is just what is going to happen when we move the building that you've already approved, that we can move on 11. Remember that you've approved a move of the 11 Victorian house 3 feet closer to 15. Well, because of the way we're doing that, the distance to the property line actually increases. So the front setback, the right side setback now that we're asking for is a little over 4 feet, 4.375 feet. But when we do the move of the building, it becomes 6.375, and that is because we're taking off a 5-foot protuberance that sticks out on the right-hand side of the building here. We're removing that, so when we move it 3 feet closer, you're actually getting 2 feet further away from the property line. I'm just saying that because there is a lot of confusion that I think Mr. Fox talked about it being like, feeling like Kowloon when the properties are going to be so close together. We're not touching the properties. We're not making them closer together. Ultimately, the thing that you've approved will move them further apart. But at present, the property line distance, the distance between the two buildings will be 8 feet when you add together the left and the right side. And when you approve, because you've approved the remodel and slight move of the house, it'll go to 10 feet between the buildings, which is nothing like Kowloon. So I think that's where I want to stand at this point and listen to some of the neighbors. I hear a lot of their concerns, but I think some of them are based on confusion because the buildings are not going to change. Nothing is going to change on this street as a result of what you're doing. The buildings remain the same. There is nothing happening. What it does do is allow the property owners the right down the road to ask to do something to the building just like any other owner of any property in Los Gatos. Thank you.
Thank you. Are there questions? Yes, Commissioner Hanson.
I had a question about the garage. I was glad to see that the condition was in there about rectifying the garage crossing the property line. But in looking at how you were going about doing it, it's the one in the middle, which makes sense because of that's where it is over the property line. But given that the garage is very old, how feasible is it to take out a section of it in the middle?
It's feasible but difficult. We just have to make sure that, because we want to try to keep these garages in the same location and not have to move them back onto the property, we have to make sure that when we demolish this garage, we make sure that there is integrity to the building that is left. Now, actually, between the garage bays, there is a plywood shear wall between each one. So it is very feasible to take this out and not have any impact on the structure of that, but you still do it very carefully.
Okay, and it is, from what you said in your comments, it is the intent of the applicant, the owners, to remodel those garages and make them more conforming in that cars could actually fit in them.
Right. In the, I nearly dug myself a hole in suggesting that we state that we would do that as part of this project that you've already approved. And we will be making that bigger. This one here, it is the intention. I've left enough room in the move of the property line to be able to grow this subsequently and make it a more feasible garage. At the moment, it's 10 feet post to post to post, and the town standard is 11 feet interior, so you have to go to about 22'6" or 22'8" width. It's only 20 feet at the moment. There is a way to do it without demolishing the garages. It's just difficult because of the way that you have to deal with the demolition requirement or non-demolition requirement, but it is achievable, and I've identified already and submitted to the town once how we were going to do that. And then I was told to withdraw that because it wasn't part of the original application that we were doing. But it is all done. The structural engineer has identified how it can be done, and it's very feasible.
All right, thank you.
Other questions? If I may, I have a question. So on the garage, if you have to rebuild that garage, are you allowed to do that with no setback?
I'm not going to rebuild it. I'm going to remodel it.
Okay. So you are not planning to come in with a demolition, for a demolition permit and rebuild it?
I'm going to have a demolition permit to rebuild, to demolish this section. I am required to do that as part of Condition 5 and Condition 7 or 10 in the conditions of approval, which says, come in and apply for a demolition permit for the garage. This garage only, not this, not this. And we would not be coming in for a demolition permit ever on this one or this one. we would be coming in for a remodel permit to make it bigger so that we can help the neighbor's parking situation on the street by encouraging 5 cars to go around the back. That's the intent of this.
Okay. I had another question, and that is, are you required to, is it necessary for you to build on 11 Peralta in order to do this lot line adjustment?
No.
Because it seems as if you don't build on 11 Peralta, you've decreased the setback on 11 Peralta, correct?
Okay. This is showing the house as it is now, not as it will be when the big bulk of the house has moved 3 feet to the north. The distance between the edge of the building now and the new property line is in excess of 4 feet. And that is compatible with other setbacks on the street and in the neighborhood. I can yes. So if you look at other setbacks, Mr. Fox from the property line is 2 feet. We're 2 feet already there. There's a 4-foot setback there. There's a 4-foot setback here. There's a 5-foot setback here. There's a 5-foot setback there, all of which are less than the 8 feet required, but it's very common in the neighborhood. So what this map shows you is you have small lots, 6,678. You have 7,442. You have 2,950. You have 5,650. You have 5,500 across the street. It's very common in this neighborhood to have smaller lots.
So
And you have that.
as a follow-up to that, when you do the development on 11, then the setback will increase over what it would be with the existing house. Is that correct?
It will get 2 feet more because we're moving the building 3 feet, the bulk of the building, the main building, 3 feet to the north, but this is 5 feet wide.
Right.
So it'll get 2 feet better
Okay.
when we do the move.
Okay.
Not any worse. It won't go down to 20 inches, which was the concern in numerous neighbors' letters, and I'm trying to
I understand.
express to them
So
that's not the case.
my question is there any reason not to proceed with the development first and then ask for the lot line adjustment? Because in this situation, you're creating a smaller setback if you do the lot line adjustment first and never do the development. And then you're saying that it'll improve after you do the development. So my question is there any reason not to proceed with the 11 Peralta development first and then ask for the lot line adjustment?
Well, the owners have the right to do that. They would like to do that. In excess of 4 feet is compatible with the neighborhood, so we were making sure that it was compatible with the neighborhood no matter what. If I were going back to the drawing board, I wouldn't move the house. I was trying to help Mr. Fox, and that didn't work out very well. But having said that, we preserved enough real estate between the two buildings that you're going to have 8 feet of separation between the buildings now. I think the other thing to note is that at the moment, the separation is not substantially less because, I mean, this is your distance. This is your 8 feet. We may be 14 feet or so from the property line, but you can't really count the property line because the reality is you're dealing with the brick wall standing there.
Okay, and then I just wanted to clarify the 4 feet. I've seen two different figures. I think one was 3 foot 9 inch, and the other was 4 foot something.
Yeah.
Why are you choosing the larger number for measuring the setback?
The setback from this building to the property line is 3'9". The setback from this building to the property line is 4'3", for a total of 8 feet.
I see, thank you. Other questions? Yes, Commissioner Janoff.
I think you just answered this, but would you confirm the distance between the proposed lot line and the house structure at 11 Peralta, assuming that it never changes?
4.375, which I believe is 4 foot, 4.5. It's in excess, in excess of 4 feet.
Thank you.
Right, 4.375 feet. Yeah. Like I said, compatible with other setbacks on the street and in the neighborhood.
I have other questions, but I think I'd rather hear from the public first, so.
Sure, absolutely.
Thank you. Okay, I have a number of speakers. First one I have is Belinda Milford and then Donna Fox.
Hello, I'm a neighbor of Peralta Avenue, and I just want to say I think it would be a real shame to subdivide a lot there because it would cause increased congestion, increased parking, and I think it's unfair to the Fox family to have a house encroaching further closer to their house. I grew up in a town that had a lot of character and charisma, and I saw it just really ruined by this subdivision and dividing lots and building more houses. I'd hate to see that happen in Los Gatos.
Thank you. Could, if I could just ask, what's your address, please?
41 Manzanita Avenue,
Okay, thank
so
you.
just a block away.
Okay, thank you very much. Donna Fox? And then Shelley Spray will be next.
Hi, my name is Donna Fox. My husband John and our youngest child reside at 9 Peralta in Los Gatos, where we have lived for over 23 years. Our house is adjacent to the Victorian at 11. The cottage at 15 Peralta currently sits next door to the Victorian. As I stand before you tonight, all of the immediate neighbors of 15 Peralta oppose this project, save one who has no opinion either way, including more neighbors up and down the street who had either previously supported the 11 Peralta renovation or who were fence sitters at that time and are now in opposition to the 15 Peralta lot line adjustment. Many neighbors were unable to attend tonight because they're out of town, so we have in your packets letters of objection on various grounds signed by at least 10 neighbors. Granting the various variants sought by the applicant would negatively impact the 11 Peralta lot and the neighborhood by making 11 Peralta a non-conforming lot by removing 1,000 square feet from it, or alternately, a more non-conforming lot. The applicants have failed to prove that there are any special circumstances applicable to 11 and 15 Peralta to justify changing 11 Peralta from a conforming lot to a non-conforming lot. If approved, this would further erode town code standards without any benefit to 11 Peralta or the neighborhood. In 2001, the town denied approval of the proposed lot line adjustment brought before by a prior owner because, unlike what Mr. Jeans said, it was deemed, because it was going to form 11 Peralta into a non-conforming lot. To now approve the current owner's application for a variance for a lot line adjustment as submitted would be to give special treatment to the current owners in violation of California state law. The applicant acknowledges that the action of moving the lot line will make 11 Peralta non-conforming. The only party it benefits is the developer who applied for this variance. The applicant is only interested in cannibalizing 11 Peralta so they can flip both properties, or at least 15. The town recognized that granting a lot line adjustment would be an error in 2001, and as a result, you must apply the same analysis so as to not grant any special privileges to the current applicant. It is self-serving for the applicant to use the lot at 15 Peralta, which is half the square footage of a conforming lot, to prove that they deserve a variance to shrink 11 to a non-conforming lot. Furthermore, the applicant's map shows the lot size and setbacks on Peralta erroneously, citing setbacks between 9 Peralta and 11, off by 9 inches in some places. We ask that you deny this variance.
Thank you. Are there questions, Ms. Fox? I have a couple of questions,
Sure.
if you may. I understand there's a position that's taken that 15 Peralta would become further out of compliance. How is that the case if that lot is being made bigger?
I always knew that the argument was that 11 would become, so they're saying that the setback, that the frontage on 11 is not 60, it's 52. They're going to make it 42, and they're going to take 1,000 square feet away. So for 15, it still wouldn't bring it in compliance because 5,000 is the bare minimum that you can have for a non-conforming lot.
So, but it would be less out of compliance.
Right, at the expense of 11, which has, a Victorian home sitting on it.
Okay. The other question I had was about the setback. I don't know if in your correspondence or others, there's a description that there's a 20-inch setback. It looks to me on the applicant plans like it's 45 inches, or at a minimum, it looks like it's 4 foot, 4.375 feet, which would be in excess of 50 inches. Could you explain to me the 20-inch
I think there was
setback?
some confusion based on the documents that were submitted by the applicant as to what the exact setback was. And one of the points that I was going to make is that he's basing that it's in conformity with the other properties in the neighborhood by saying that, like, there's, it's the same as between 9 and 11. Well, 9 was built in, 1890, and it was following a different code. But if you're making changes now, you need to live up to the code that's before the town currently.
Okay, thank you. Any other questions? Okay, thank you very much. Next speaker I have is Shelley Spray, and then Art Monk.
Hi, everyone. Thank you very much for the opportunity to speak with you.
And
I've
could
been
you
a
give your
resident-
address, please?
Oh, yeah, 20 Hernandez Avenue, and that's, if you look at Peralta, right where it ends is Hernandez, so if I stand outside on my sidewalk, I can see this property. I walk by it every day. I first wanted to thank you for the opportunity to speak and also say that there are a lot of people that are very passionate about this and very concerned about it. And I first want to start with just some history on the lot. We talk about the lot line, this lot line being adjusted, but if you go back and you look at it, in 1907, 11 and 15 Peralta were sold as one lot. And this lot was subsequently sold 20 times as one lot over a 112-year period of time. It's never been subdivided as a separate lot. And a matter of fact, if you look at some of the, how do I do this? So if you look at 1895, these are the two lots. So this is the lot line that they're looking at, and they're trying to move this lot line. But if you look at 1928, there's no
Yes,
lot
I'm sorry. Would you mind to take the mic from the podium when you go over there, and just start again if you don't mind? So we'll give you back your time.
Sure, thank you very much. So if you look at 1895, this is the property where the Victorian house is sitting. This is the lot line they're talking about. This is where the cottage was built. This goes back to 1895. If you go to 1928, this is the property that we're talking about now. This is the first time that you see something that shows the cottage represented on it. You have the Victorian building and you have the cottage. There is no lot line at all. So we keep talking about this lot line and moving this lot line. There's no lot line to move. This was sold for 112 years as a single plot of land. That's it. And it's had a single common owner. If you walk by that house, there is a single entrance going up the stairs. There is no other entrance going onto the building. It looks like one Victorian home with a little tiny building next to it. If you go around the back, there's another entrance. There's 6 garages that are lined up that are next to it, and it all looks like it's one building. There's no lot line. For 112 years, there's not been a lot line on this. So what's happening is you have the owners of it going back to a document that says 1895, finding this said lot line, and then deciding that they want to move it so they can, in fact, subdivide that lot and sell both of those lots off. That's why they want to do the lot line first versus any type of renovation, so that they get that lot line, and then once that renovation's done, they can subdivide and sell. And that's what we don't want in our community, is this constant subdividing. If you go on and you Google and you look at the vanishing San Francisco, vanishing San Diego, vanishing all of these places, that's what happens. You lose these beautiful, elegant homes that are there because people start looking at their garages and tiny plots of land on it. We don't want developers walking around looking at our properties and trying to figure out how to subdivide and sell these properties off. Yes, in 2001, there were 2 requests made by the owner at that time, certificate of compliance, which was approved, but there was a lot line adjustment that was asked for, that was not approved. And subsequent to what was described over here, that was not the case. It was denied because the cottage needed to sit on at least 5,000 square foot of property, and it does not, and it can have a separate property line if it's shared by the same owner. This is the same owner. One person owns this house. Also, the cottage is a historical building. It is beautiful. It's represented next to the Victorian. You do not want to separate those. Seriously, the Historical Preservation Committee would have to come in and look at that. You can't separate those 2 buildings just randomly. And then finally, what I wanted to say was, again, do I get that time back, Mike? No, I said it before. We just are so worried about this subdivision and having our beautiful area that we live in start to get broken into tiny pieces and sold off with these tiny properties and little spaces. We really love where we live, and we don't want it to change.
Okay, thank you. Are there questions? I had a couple of questions. You mentioned the Historic Preservation Committee, and my question to you would be that if a modification, if no modification is proposed to the 15 Peralta address, and this application I don't believe is, on what basis would the Historic Preservation Committee look at this application?
It's about the lot line and whether there's actually a lot line there to move. So if we move this phantom lot line, then the property owners could sell the property and split those 2 components up. That's what I'm saying, is that this is relative distinction between the 2 properties as they sit, to separate those and to have this phantom lot line become a lot line that can now be moved, allows them to sell off property and to separate those 2 units.
Thank you. That triggers a question that I'll have for staff later about the purview of historic preservation.
Okay.
I had another question, which it sounds as though there were 2 decisions made in 2001. One was a certificate of compliance, and one was a lot line adjustment. And the question I have is, and have you given any thought to, under what authority could the town rescind the certificate of compliance that it gave in 2001?
I'm not sure I understand the question. Do you mean to pull it back and say that they don't have the certificate of compliance?
Correct. Right, because you've stated that it's one owner and that they can't do anything there with regard to that. So it sounds like you're saying that the certificate of compliance would have to be rescinded. Is that correct? And if so, under what authority could the town rescind a certificate of compliance?
No, I'm actually saying that there were 2 things that were submitted. I don't know if the certificate of compliance could be rescinded or not, but what I'm saying is that they asked for a lot line adjustment and it was denied. And it wasn't denied. You can go into the documentation. It is in the information that you have. But 2 key reasons why is that it needed to sit on a 5,000 square foot property, which it does not. That's number 1 of 1.291017 or 07, and it cannot have a separate property line if it's shared by the same owner. Those are 2 main reasons why. So what was described before is that they didn't describe what was going to happen with the garage. That's not the reason. The reason why is that it wasn't the lot size, and you can't split it if you have one single owner. Those were the 2 main reasons why.
Thank you. That again triggers some more questions for staff later.
Okay.
Thank you very much. Any other questions? Okay, Mr. Art Monk. And then the last card I have is David and Melanie Cox. And if there's anyone else who'd like to speak, please just turn in a card.
Yeah, you can give me a bit of help here. I don't know. Okay. And, no, I just want this. That's all I do want. Yeah. Thank you so much, Aaron. Good evening, Chairman Hoods and honorable commissioners. My name is Art Monk. I live at 33 Peralta. I'm here to talk briefly about some things you have in your packet, and we're going to talk about our friend 2910-070, and I received a document today that said it really doesn't apply, and I'd like to talk with you about why it does. And we're going to talk about the California Subdivision Map Act, and you see there the particular reference to what we're talking about, the Los Gatos Town Code, and then we're going to understand that the applicant has crafted a proposal in a manner to escape the prongs of 2910-070A1 and 8, and he's done that by tearing down the garage and making the plot 5,000 square feet for number 15. These activities are categorically forbidden in 2910-070, and the reference is at the bottom there where you say, no parcel shall be modified through a lot line adjustment procedure in order to meet the criteria listed above. Listed above are those criteria when you read the particular citation. So we're going to have a careful read through 66451.11, which is state code. And of course, as you know, Los Gatos is a general law city, so the state code is effective here. And the careful read goes like this. A local agency, that's the town of Los Gatos, may, please keep that may in your head, by ordinance which conforms to and implements the procedures prescribed by this article, provide for the merger of a parcel or unit with a contiguous parcel or unit held by the same owner. Contiguous parcel or unit held by the same owner. Those are two lots that are beside each other. If any one of the contiguous may, remember the may, if any one of the contiguous parcels or units held by the same owner does not conform to standards for minimum parcel size under zoning ordinance of the local agency applicable to the parcels or units, all of the following requirements of land, and if all of the following requirements are satisfied. Here we go. At least one of the affected parcels is undeveloped, and it was at this exact point that we had a confusion point with legal representation at the town. And so the way this reads is, by any structure for which building permit was issued or for which a building permit was not required, or is developed with an accessory structure, or is developed with a single structure that is partially sited on a contiguous parcel or unit. In other words, that particular second or takes you to a situation where you have a building across a lot line. So I'm out of time.
Okay, but there may be questions. Yes, Commissioner Burge.
So we only got through A. So I'm going to ask the chair if I may request that he just at least finish the description on this document so I fully understand the point that he was hoping to make.
Sure, maybe you could just ask a question.
Would you be willing to do a bit more description on this page? I'm going to be clear that we can't go through all the pages.
Happy to do that.
Just as far as this, I want to fully understand the documentation you've provided.
Certainly. I will put it back up. So there it is. But before I do that, I'll put up the note that we received from attorney that says, therefore, the town, including Planning Commission and Town Council, has no legal authority or ability to rescind the certificate of compliance, and we're not here to have it rescinded. It hasn't hurt anybody since 2001. Leave it there. All right? Government Code Section 66451, which was in contention, .11, cited in public comment, is not applicable as this property, now here's something you need to look at closely, does not satisfy all the requirements, specifically that at least one of the affected parcels is undeveloped by any structure.
For clarification, could you refer us, this is a document that we have?
That is a document you have. Well, you would have it in your packet from staff. Those are comments.
Desk item from
Yes,
today?
yeah.
Okay, thank
That's
you.
in, I don't know if it's in your desk item.
Yep.
You have it, okay. So what I'm here to say is this poor section of town code has been left in the cold for a long time in both of these instances. And so I'm going to come back to how it needs to be read. Now, firstly, we're going to read this, Commissioner Birch, I am going to answer your question. I am, okay. But what I'd like to add here is, you have here the state code, and you have it in the documentation that I provide. You have the state code in 1985. You have it online right now, the state code of the California Subdivision Map Act. Then you have Los Gatos Town Code, Ordinance 1750 that was introduced on July 18th of 1988, went through voting and was signed into law on the August the 1st of 1088, has very, very similar language. The prongs of that language are the same, the words are slightly different. But that went into the town ordinance in 1988.
Mr. Monk?
Yes.
May I ask that you address Commissioner Birch's question?
Good.
And then we do have this document, and this will be helpful
Perfect.
when we question staff.
A careful reading. A local agency, that would be the town of Los Gatos, may, doesn't have to, but may, by ordinance which conforms to and implements the procedures described in this article. Okay, so this article is the article in the code, the California State Code. So the town may provide for, it doesn't have to, but it may provide for the merger of a parcel or a unit with a contiguous parcel or unit held by the same owner. Doesn't have to do that, but it may. If any one of the contiguous parcels or units held by the same owner does not conform to standards for minimum parcel size under the zoning ordinance of the local agency, that is the town of Los Gatos, applicable to the parcels or units of land, and if all of the following requirements are satisfied, colon, there is a colon there, hard to see because it's in blue, but there's a colon after the word satisfied. A, there's an A and a B. A, at least one of the affected parcels is undeveloped. Well, in the earliest of days, that's how Mr. Willits, I think his name is, back in 1906, bought it as raw land. But nevertheless, let's carry on. By any undeveloped by any structure for which a building permit was issued or for which a building permit was not required at the time of construction, comma, all right? Now, if you only read that far, then the comments that we see here would be true. Those comments that were brought to our attention by the attorney. But there is a large or right there, and it says, or is developed only with an accessory structure or accessory structures. There's another or is developed with a single structure other than an accessory structure that is also partially sited on a contiguous parcel or unit. That says, or if there is a building that's built across a line. Okay? Then it says, with respect to any affected parcel, one or more of the following conditions exists. Comprises less than 5,000 square feet in area at the time of determination of a merger. And that's in fact exactly the case. There's 4,000 square feet there. There's a building across the line, and that is what this code is talking about.
Thank you for walking us through that. It's helpful. Are there other questions of Mr. Monk? I had a question which is similar to the one earlier. I believe that a certificate of compliance was issued in 2001. how would rescinding that not be a taking of property by the town?
We're not here to ask that be rescinded. In your package, you can see a breakout chart you probably can't read that, but a breakout chart you would have in your package that talks about the certificate of compliance. And yes, we believe at the time it should have been a conditional certificate of compliance, which is talked about in California MAP Act. So, and we then said, all right, let's look at this. And it turns out there's actually no statutory method for removing a certificate of compliance. And our view is that since 2001, when the certificate was put in place, things have been fine because it's been common owners on either side. People have been acting like the property is merged. And so it could continue on that way. And if the new owners of the merged property came along and said they wanted to file a new map where those two were together, that would be on them, and they would approach council for that.
Thank you. I had one more question.
Yep.
In a letter that you signed and several others signed, there's a statement that says that subdividing the property into small parcels is inconsistent with the character of the neighborhood. This is going to be a key consideration for us. How is this not compatible with the neighborhood?
Well, it's over and above that, it's not compatible with the history of the property, of being a single owner property that's been.
I'm talking about the neighborhood compatibility in terms of similarity of
Well, what would have to
conditions.
happen if it was truly going to be a separate lot is a new curb cut would have to be created in that stone wall. That wall would have to be torn down and a separate entryway put in to that lot, because right now to the two lots, there's only one stone staircase to go in. And, you know, there's those kinds of things.
Okay, thank you. Last speaker I have is David and Melanie Cox.
Good evening. Good evening. I'm David Cox. I live at, my wife Melanie and I live at 41 Peralta. We've lived there for nearly 10 years. We are against this for the reason, you know, based on what we've heard tonight. I think for us, there are a couple of things. What Mr. Jeans said as one of the reasons was that, if I understood it right, this cottage on the property right now, they are not free to modify or update because of this question around where the property line is or whatnot, or because the property line goes through the house. My understanding is I struggle with that reason, because if it's a single property and a single owner, I can't imagine the town would have a problem if I own that property and I wanted to keep it the way it is, to go to the town and to say I want to update my cottage. Why wouldn't the town let me do that? I didn't understand that. It seemed like not a valid reason. But the main reason why we have a problem with this is because it just feels like this has been a single property for all these years, and it just feels like developers coming in and dividing it up for their personal gain, and that it very much disrupts you know, what's been going on for 100 years on this street, and it's non-conforming, and so it just doesn't make sense.
Thank you. Other questions? Okay, thank you.
Thank you.
That's the last card that I have, and so at this point I would invite the applicant back for 5 minutes to address the commission.
Is this okay now? Thank you. I'm going to skip through it fairly quickly. This is the legal description of 11 and 15. You'll see it calls out parcel 1 with an APN, parcel 2 with an APN. This description is pursuant to the Town of Los Gatos Certificate of Compliance recorded 2001. They are two properties. You are dealing with two properties here. That is a fact. That is what it is. And any attempt to try and say that it is not two properties is wrong. One of the things that I gave you, common ownership, this is from Subdivision Map Act, which is really boring, but it's got some points in it. Common ownership does not constitute grounds for determining lots to be merged. What it says is 2 or more contiguous parcels or units of land which have been created under the provisions of any prior law regulating the division of land shall not be deemed merged by virtue of the fact that the contiguous parcels or units are held by the same owner. That's the law. The fact that there's an interesting thing that actually is in Mr. Monk's documents, where you discover that the very first time they were transferred in ownership were in 2 separate years, 1988 and 1906. That, in turn, constitutes them being regarded as 2 separate parcels, which is why in 2001, the town issued the certificate of compliance. The title company in 2001 said, in our research, we found no documents nor any references in any deeds indicating that the 2 lots were ever merged formally or informally. So they haven't been merged, they are 2 lots. They haven't been merged, they are 2 lots. So where does that put the homeowner now? It puts them in a position that they can't do anything with the property. The neighbors are suggesting that this is a travesty based on lot 11 becoming smaller. I think it's a travesty that they can't do anything with the property. And this is really stopping them from developing their property in a sensible fashion. The document that you were looking at just now and you were talking about, and I can't find at the moment, was in your packet that was, here it is. This is from your town attorney. This is his analysis. You have this in the handout that you got tonight. This is his legal analysis, and this is the one that I want you to understand. I'm a neophyte looking at the Subdivision Map Act. Your town attorney is much better at it than I am. But he states numerous situations. If you go onto the second page, what he ends up saying is, since the town was legally obligated to issue a certificate of compliance for the parcels at 11 and 15, it is the town attorney's opinion that any attempt by the town to rescind or revoke the certificate of compliance would result in a property taking and liability to the town for the value of the parcel. I know Mr. Monk said, well, we're not asking him to rescind it. Well, what is he asking to do? We can't leave it running through the building. This is what we're here to do. We're trying to normalize a situation so that 2 primary residences can be treated as 2 primary residences. And if you go back to the situation on the street, once more, having a 7,000-foot lot is not inconsistent with the neighborhood. The lot directly behind it, across the alley, is 6,600 feet. Across the street, we're 55, and we have numerous other ones in the neighborhood. Thank you.
Are there questions? I had a couple. Question is, if the lot line adjustment were not granted and the owner has this property at 15 Peralta, What size home could be built on that lot?
It's in one of the tables. Let me find that. The problem is, if it were not granted, well, I think the real problem is, how do you build when the property line is running through the building? I don't know how you do it, because I won't get permission for a building permit. I won't get permission for a planning permit. Let me see if it's on here. If it were a 4,000-foot lot, building area 15, I could do 1,432 square feet. After the lot line adjustment, it could be 1,500. You get an extra 68 square feet. Not a lot. You can always do, I guess, a basement. But that would be the size that you would be allowed to do.
And is that a single story?
Yeah.
Single
Well, could be anything. It could be
that's a
700 over 700.
Right, okay, got it.
At the moment, it's a two-story.
Okay. The other question I had goes back to your opening statement, and I wasn't clear because I think you said two different things.
Okay.
I believe you said that 11 Peralta was a conforming lot. You said it was an 8,000 square foot conforming lot, and then later on you said it's a non-conforming lot. Could you clarify that? Do you consider it a conforming or non-conforming, 11 Peralta?
11 Peralta, I thought I had always said it's non-conforming. It is non-conforming. It is conforming because it only has 50 feet of frontage. It's required to have 60. The setbacks on the side are non-conforming. The lot size is conforming, but it's non-conforming from the front setbacks. And in fact, on that table that I had up there, and you have a better picture of it in your, because you can't really see what is red and what isn't. But all of the non-conformities are shown on this chart, and there's also one without the yellow. The one without the yellow is showing it as it is now. The yellow is only showing, hey, we know we've got approval to do a remodel and an addition on 11, so what impact does that have? But the bottom line is that shows where the non-conformities are and where they're changing.
Thank you. I think you answered the question. The related question to that is are non-conforming lots prevalent in that neighborhood? Because there's a consideration and a finding that we would have to make about this as compared to other neighborhood lots.
The answer is yes. So, again, going to this one, from a size standpoint, this is non-conforming here, right behind the property. This is non-conforming for size, for size, for size. So there are 3 on this street or in that area for size. There are 1, 2, 3, 4, 5 with frontage, non-conforming. And there are 1, 2, 3, 4, 5 with setbacks non-conforming. So it's very prevalent.
Okay, thank you. Other questions? Okay, I will close the public portion of the public hearing, and we'll move to questions of staff. Yes, Commissioner Birch.
Chair, is it all right if I ask more than one question because
Absolutely.
they relate to one another? So I have some confusion with some of the documentation, and where I'm going to start with is I believe the DRC meeting minutes that we have. I don't see a date on them, though. I'm so sorry. Well, anyways, we have meeting minutes from a DRC meeting, and item number 9 was for the properties in front of us, and it is specifically requesting approval for a certificate of compliance to legalize 2 parcels and a lot line adjustment. So my question with this, because I want to make sure I'm very clear before I go farther into questions, is it sounds like I'm then reading the comments from it, and I'm not really clear on the certificate of compliance that legalized 2 parcels. Is that what that was granted, correct? Because I'm not clearly reading that in this, but I could be reading it wrong.
That's correct. At that meeting, the certificate of compliance was approved.
So does that legally mean that became, whether it had been or not, because it's kind of murky. I get that the land was deeded a long time ago, it was deeded to one person, but it had been 2 lots. Does that action mean legally this was confirmed as 2 separate lots, 2 separate parcels?
That is correct.
Okay. So the issue of this being one property that is now being divided is legally not accurate. Is that correct?
That is correct.
Okay. Then that answers that question. And then my next question, in fully understanding that, is when that was granted, the lot line that was determined, and I'm not certain how that was determined, actually. I assume it was just based on the property that was deeded in the original lot line. Was it at that time already running through the existing cottage and garage?
At the time of certificate of compliance, that's where the building was, and that's where the property line laid.
Okay. And then I only have one other question. So that being the case, and that being that it was an existing building where this was, if that person, if somebody wanted to do work on that cottage, they wanted to add an extra room on the back or something, does the fact that that lot line lies within that building mean they can't do anything?
Yes, that's correct.
Okay. Thank you.
Thank you. Commissioner O'Donnell.
I just want to throw this out for our discussion. It seems to me we have essentially an opinion by the town attorney that, 1, the certificate of compliance is valid, and 2, that it's subsisting, and that if we were to do something contrary to that, we might have a taking. I'm going to accept that because I don't think it's our purview to argue with our own attorney unless we have some newly discovered evidence, and I practiced law for almost 50 years, and I would not argue with the town attorney on this. If you accept that the certificate of compliance does not make something, it signifies that something is compliant based on the facts. So pre-existing facts are signified as being compliant, it's my understanding. In any event, we have the compliance. So I guess, notwithstanding that it is in compliance, one question we're dealing with tonight is, do we want to do a lot line adjustment? Because as we know previously, where the certificate of compliance was granted, they did not grant the adjustment. So we're being asked, to me, it's not an issue anymore about are there 2 lots, because we have a certificate of compliance. That's the only question is, should we, to me anyway, should we grant the adjustment? So if somebody views that differently, we want to talk about are there 2 parcels or not, I'd like to hear why. If not, then I think we ought to deal with, should we grant the adjustment?
So maybe I could just go to staff for one minute before we get and get staff's read on, are those the questions that we're dealing with, and is that the position that staff takes on that?
Yes, that's accurate, and also you have a variance before you this evening, which is in order to enable the lot line adjustment, which the Development Review Committee did not have before them, and hence also why it's before the Planning Commission.
Okay, thank you. Commissioner Birch.
Just to clarify, the reason I specifically asked those questions is I do hear the concerns of the people in the audience, and I want them to understand that as we move forward, that we do understand that, but what legally we are bound to. So I do not think that an open discussion on whether this is 1 property or 2 is a valid discussion.
Okay, Commissioner Janoff.
Yeah, thank you. I'm in complete agreement with my fellow commissioners as stated. And just also wanted to follow up that the comment on the DRC meeting in 2001 that we're referring to indicated that one of the reasons for not granting the lot line adjustment is because the garage straddles the property line. They don't happen to mention the residence. So in fact, what we are presented with is a correction of a deformity or a deficiency that was identified in 2001 in terms of what Mr. Jeans is proposing. Having said that, my one concern, given that they are two legally separate lots, two APNs recognized by the county, two tax bills. The comment that if we separate the lot at 15 Peralta and agree to the lot line adjustment, that would enable future development to update the home. Would it also require that there be access to the home made through the existing stone wall? This is a question for staff.
That was posed to Public Works, and at this time with this application, that's not required. They have, there's the same property owner. Any future development with a separate owner would require separate access. There is access through the rear as well.
Just to follow up, please. And since that property, presumably the wall as well as the structures, are historic in nature, would the break through the historic wall have to come before the Historic Preservation Committee?
Yes.
Okay, thank you.
Just as a follow-up to questions that were raised earlier, could staff clarify the difference between the 2001 application for lot line adjustment and the one we have before us tonight?
Yes, that application did not include a request for a variance. So what was denied was that, yes, the lot line adjustment created a lot smaller than the required 8,000, so it would require variance. So they did not request that at the time, and there also did not show on the plans how to handle the garage crossing the property line.
Okay, thank you. Commissioner Hanson.
I wanted to ask two questions. One was, I just was wondering, since staff is recommending approval, what were your main reasons for recommending approval of the application? You know, that it would be better than it was before they requested the lot line adjustment?
It remedies the condition where the applicant isn't able to, the property owner is not able to modify the existing home because of the property line running through, and it is compatible. Reduced lot size and lot frontage and reduced setbacks are compatible within the neighborhood. There's evidence of that.
And you do concur that that both properties are currently non-conforming?
That's correct. They both are non-conforming.
And then just related to that, it's just kind of the same question. I just wanted you to comment on, we have this concept of legal non-conforming because we have a lot of residences that might have been built the way they were before our code changed or anything like that. So, you know, generally speaking, what is our town view on when something comes up for approval, when it's been established that it was legally non-conforming? Do we typically ask them to correct the non-conformity as a condition of approval, or, you know, but because or is it grandfathered because it happened before the code changed?
So for building conditions, non-conforming building situations, you are able to maintain a non-conforming setback as long as you don't demo the building. As soon as you demo the building, it needs to come into conformance, or you need to come request an exception or a variance. Building things such as building height, which is not the case in here, would have to meet the zoning standard at the time.
Thank you.
Other questions? Commissioner Birch.
One follow-up from my earlier questions, just again, reading my notes from the neighbors. As this is currently two properties, even though there is one owner, technically, they could sell one lot right now, correct?
They can. Yes, I think they can sell one lot.
Okay. Other questions? Okay. Anyone want to kind of start the discussion with their thoughts? Commissioner O'Donnell?
Well, we've said that, yes, there are 2 lots, yes, there is a certificate of compliance, which we have to recognize. We also have to consider the variance, but before we consider the variance, we probably have to consider whether we want to grant the lot line adjustment, because if we do, then we have to grant the variance. If we don't want to do one or the other, then we can't do the totality, I guess I'm saying. Without the variance, there's no point in trying to grant the adjustment, because it isn't right. So these 2 things go together. Should we grant the adjustment, and should we grant the variance? So far, what I've heard is, if they were to sell one of the lots, we've got this very strange situation where a building is straddling 2 pieces of property, and I, for one, think that's crazy, and we ought to do something to remedy that. It's been, one way to remedy that is what is being suggested tonight. They've agreed to move the building, which, in retrospect, we're told that was done to accommodate, to try to reach some kind of settlement, which didn't occur. So it would have been conceivable not to offer to move the building, but we have that of record, and that's what the deal is. That will mean that the lot line between the 2 lots will be greater than they are presently. So I guess I can't, once you accept that line of thinking, and I do accept the town attorney's view here, I can't think of a reason why you wouldn't want to grant the adjustment, and if you wanted to grant the adjustment, you would have to grant the variance. So I guess what I'm saying is, if either of those thoughts, variance and or adjustment, strikes any of you as no, we shouldn't do that, I would invite some help on that.
Commissioner Hanson.
I like Commissioner O'Donnell's line of thinking. I mean, it is established that there are 2 legal lots. That's not a subject for debate. And so then the question of whether the lot line adjustment, staff gave good reasons if they're unable to make modifications to their property if you don't make that. But having said that, one concern I heard loud and clear from the neighbors is about subdivision. And I too, if I lived in that neighborhood, would be worried about, could other people use this as precedent and come in and subdivide their lots? But I don't think that could be the case, because this is already established as 2 lots, and we're simply moving the lot line over a little bit to rectify the fact that they can't make any enhancements to their property. So I would ask our town attorney to just comment on that, though, that I'm correct in saying that this would not be a precedent for somebody down the street to request a subdivision.
I think that's correct. These cases need to be analyzed on their own merits. And so this is not a situation of a single lot that is requesting right now to be divided. And we have 2 distinctly divided lots legally back to 1888, I'm sorry. So I don't think it would serve as a binding precedent.
So, thank you. So that being the case, given that it's 2 lots, given that the lot line adjustment would correct some deficiencies, and given that we presumably wouldn't set a precedent for further subdivision in that neighborhood or anywhere else, I generally support the request.
Another question for staff that I had asked in the hearing earlier, and that had to do with the sequence of when this is given. Do we have any ability to have the lot line adjustment occur after the redevelopment occurs? In other words, we were told in testimony that when the redevelopment occurs, there will be more space. Even though the building's moving over, the configuration of the building is such that there'll be even more space. And so it would seem as though we would have less of an issue on the lot line adjustment after the development has occurred. So is there any way for the lot line adjustment to be either contingent or dependent on that development occurring?
So I can jump in a little bit here. Joel Paulson, Community Development Director. You should act on this application that's before you this evening as if the movement doesn't occur. You are approving the variance for the 4.375 feet on 11. So that should be the mindset, and you should take the evidence and facts that support that from staff's perspective and make a determination on these applications this evening.
Okay, thank you. That's very helpful. Other questions? Commissioner Birch.
If I may, can I ask a question of staff and then make a comment? As these are non-conforming lots, if they decided to do work on 15, I assume that would come in front of us. Is that correct?
It depends on the scope of work. If they meet all the, just because a lot is non-conforming, the town has many non-conforming lots due to frontage or size. As long as they meet the zoning standards in terms of setbacks or, and lot coverage and, if they meet all of that, they may not come before Planning Commission. However, if they are asking for an exception or maybe there's an architectural concern or something like that, it may come before you.
Okay. And then if I could just make a comment.
Yes.
Personally, if this was one lot, I would never divide this. I've been on this commission where we've divided lots into two, and we are extremely fastidious on meeting the requirements, particularly on the frontage width. But it is, based on all the documentation, two legal lots. And it sounds like some of the concerns the neighbors have actually have the potential of happening right now. They could sell one of those. It could get modified. So really what's in front of us is just cleaning up a lot line, which does make sense. I would hate for somebody with, a couple to move into that cottage and then expand their family and have no ability to do something. So I will support it.
Commissioner O'Donnell.
Just to follow up on that, we did hear what was said tonight, but I want you to know what we feel we can do. I don't believe what you're concerned about will come from this. In other words, if this were not two parcels, we wouldn't be having this conversation. If we had some magic way to say they aren't two parcels. But in fact, in 1898 or whatever the date was, the initial conveyance occurred, and subsequent in 1928 was second. It's always been two parcels. To the naked eye, everybody thought it was one, because it's just, how do two parcels look? They don't look any different than one if they're next to each other. So I just want people to understand that in our analysis is not rejecting your concern, but I think we are saying, notwithstanding that we do feel somewhat compelled by the facts and by the law, I don't believe you're going to have the result you're worried about. This will not be precedent for anybody to come in and say, oh good, we want a parcel map filed on the lot, or we want to subdivide it into two. We're not saying that at all. We're saying it is two. There is an intrusion of a building across it. How many times is that going to happen? So I feel bad to listen to you and feel like we should be doing something for you. But very frankly, we are doing something for you. We're observing the law. And were we not to observe the law, forget the fact that that wouldn't be a good thing. But secondly, there's liability here, which might mean we'd have to pay money for the lot we just pretended like that wasn't a lot. So I don't normally explain this, but I respect all of your opinions. I just want you to know why we may go the other way.
I had maybe one more question for staff related to that, and in terms of the lot line adjustment and and the variance in particular that supports it. There's a part of the code 2920-170 that says that this application of this ordinance deprives such property of privileges enjoyed by other properties in the vicinity and under identical zone. And with regard to that, I think testimony and evidence about what is prevalent in the neighborhood is important. So I wanted to get staff's opinion on that. We heard some testimony tonight, but my question is, are there other examples of non-conforming, perhaps with irregular lot lines in that vicinity?
There are. There's properties with non-conforming frontages and non-conforming lot sizes and setbacks within the neighborhood.
And in the correspondence 36 Peralta was cited, 324 Pennsylvania, 66 Pennsylvania, 20 Glenridge, and 22 Glenridge were cited by the applicant. Are those ones that you're aware of?
Yes, they are.
Okay, thank you. Commissioner Badami?
With all that's been said, and that includes the evidence and facts before us, I would find it difficult to deny the application, so I would support a motion to approve. All right. All right. I move to approve subdivision application M-19-001 and variance application V-19-001, requesting approval of a variance for a lot line adjustment between two lots for property zoned R18. I can make the required findings for CEQA. I can make the required findings for granting a variance application as required by section 29.20.170 of the town code. And I can also make the required findings of the Subdivision Map Act consistent with section 66412 as contained in Exhibit 2.
Commissioner Birch?
I'll second the motion.
Okay. Commissioner Hanson, remark?
Would the maker of the motion care to add the conditions in Exhibit 3, which includes the requirement to demolish the garage?
Yes, absolutely.
Yes.
Question of staff, is that motion complete with regard to this matter, including variance and things like that? Okay.
Yes.
Further discussion? I would just maybe add one point, and that is that a lot of this obviously hinges on the determination of whether this is two properties or one. And I will definitely rely on legal counsel's advice with regard to that issue. I hope it's right, and I also, but really feel like the only way I can deal with this in front of me is to rely on legal counsel with regard to that particular issue, because I think the other issue follows from that, in my opinion. So, other discussion? Okay, I'll call the question. All in favor? All right, okay. Opposed? Passes unanimously. Are there appeal rights for this?
Yes, they are. The decision of the Planning Commission is appealable to Town Council within 10 days on forms with fees payable to the Town Clerk's office.
Okay, thank you. So the last item we have, number 5, is other business, and report from Director of Community Development, Mr. Paulson.
Thank you. I will go ahead and do this from back here. So last night, the town council met, and they discussed the recommendation from the Planning Commission regarding the land use appeal modifications. They introduced all of the ordinance with the exception of the findings. The findings section they asked to be left the same as it was, as it is currently, and they have remanded that back to the policy committee for some more discussion. So that will go to the policy committee for further discussion. So we may see that topic come back through the Planning Commission and then ultimately the council, depending on their recommendation. And then they also authorized the town manager to work with Parks and Public Works on the specs and bids for the one-way street pilot. So tentatively, the one-way street pilot is set to begin in early June. I want to say June 8th or 9th, and then run, I believe, till October. So it will be one way from Bachman to Elm. The town will be putting in is proposing to put in 7 parklets for the public, which will be, places for folks to gather and sit. Those haven't been programmed yet. And there'll also be a bike lane installed, and then there'll be on the east side of North Santa Cruz, there'll be angled parking where they can put that in, and on the west side there'll be some parallel parking available. And actually, the net increase is 3 parking spaces after all that's said, which is interesting. But we will see how that pilot goes, and so those are the 2 items that I have to report.
Okay, follow up with regard to the first item. Is there timing for the policy committee to reconsider that item?
It will probably go to the next meeting. I think we're still looking at which date that's going to be, whether that's going to be next Tuesday or it's going to be 2 Tuesdays after that. So I would just, if you want to, I will shoot you an email and let you know when I
Okay.
find out.
Great, thank you. Last item is subcommittee reports. Planning commissioners serve on several subcommittees. I know we had a meeting of the Conceptual Development Advisory Commission earlier today. Commissioner Badami, would you like to give an update on that?
Yes, the Conceptual Development Advisory Committee met earlier this afternoon. That would be with Chair Hudis and Commissioner O'Donnell. We reviewed a potential project for Wood Road, which was a proposal to rezone a property from HR 5 to HR 1 and for a subdivision of one lot into 2 lots. We had quite a robust discussion of fire safety relating to the site characteristics of steep slopes, limited access, and fuels, meaning brush, trees, vegetation, etc.
Yes, Commissioner O'Donnell.
I just want to add, for those of you that have never tried to pursue that road to as far as you can go, it is a thrill. You get up there and finally there is a gate. Unfortunately, some of us had the right passcode and we could get in. But I'll tell you, that you've got views that just won't die, but getting there is a challenge. Enough said.
Great, thank you. Anyone else? Yes, Commissioner Hanson.
The General Plan Advisory Committee had its fourth meeting on April 30th, which was a little over a week ago. And we were continuing our discussion of the vision for the 2040 General Plan update. And in the previous meeting, we had some draft of a vision statement, and then staff did a great job of pulling that back together and also supplying us with vision statements of many other jurisdictions. And then a couple of the committee members also put in their own views. So we had a very, very lively discussion, but we did take the best of all of the submissions that we had and crafted a vision statement that I think we're pretty happy with it. We're also tasked with completing guiding principles, which will be kind of like the next level of detail. And that discussion will happen in our next meeting because we spent so much time on the vision statement. But it really, really was an excellent discussion, and all the members of the General Plan Committee did an excellent job of contributing to the vision that we have for 2040. And then that vision and the guiding principles will come to us, the Planning Commission, as well as Town Council. And then once we get through that process, we will start diving into the actual elements of the general plan, starting with the land use.
Great, thank you. Are there any other matters that the Commissioner wishes to discuss? Okay, well, thank you very much. This meeting is adjourned.